It's a bad message. It's an attack on liberties. The right to bargain is a liberty protected by the Quebec Charter of Rights, by the Canadian Charter of Rights, by the Supreme Court of Canada. It's very clear that you have the right to bargain, and almost nothing can restrain this access to the right of bargain. It's a civil liberty that Mr. Boulay is attacking this morning. It's a dangerous precedent. He obviously looked at the federal government and is trying to mimic what they've done. He had a good record, Mr. Boulay, as a minister. He's one of the few labor ministers to have not voted a law to oblige people to go back to work. Most of the recent history, labor ministers have done one or more of those bills. He never done it. He was proud of that, and I was proud of him too for not doing that. For 6 years as he's been Minister of Labor, but now he's doing worse. He's adopting a law that can prevent any kind of conflict by just sending it to the Tribunal du Travail.
What do you think led him to make this decision?
It's a good question. I don't know. I know him for 6 years. I appreciate him. We are not often on the same page on a lot of issues, but I appreciate the guy. I don't understand where it comes from. Is it a vengeance against the strike of the teachers last year? Is it something to prevent the strike coming in the daycare centers, the CPE? Is it a command from Legault? I don't know. It's obviously the same thing, they're copy-pasting from federal government, but either things, the federal way to work and the bill Quebec is proposing, they're not going to resist Supreme Court judge in a few years. He's just buying 5 or 10 years of doing so before the bill goes up to the Supreme Court. He just shoving the thing to the next minister, to the next government.
But what makes you so confident that it wouldn't get past a court challenge?
Because the reason we're doing this is because we have done a bill 5 years ago, in 2019, from Mr. Boulay himself, to redefine what essential services means, to restrain the criteria of what essential services means, because the Supreme Court had ruled that the criteria were too big. You could define almost any conflict as essential services. So we redefine it as physical security of persons. If the conflict, lockout, or strike makes endanger the physical security of persons, then we can apply the essential services law. But now we're just going on the side of it, contourner, how do you mean that? Circumventing it by this bill, sending it to the tribunal, saying that you deal about that, but with the objective of ending the strike or the lockout. Nobody likes a strike. I was a union advisor for years before becoming a member of this National Assembly. I didn't like strikes. It's complicated. There's a cost stress, a living stress on the strikers. They have less money. They are having problem paying their rent, their mortgage. We don't know how to make the table of bargaining moving. It's complicated. Nobody likes that. The strikers don't like it. The union advisors don't like it. The population don't like it. Nobody likes a strike. But it's the only thing that remains, the only tool that remains to the workers to bring some attention of the bosses to the table to bargain. It's the only tool they have. So when you have governments trying to restrain this tool, which is a civil liberty, the right to association, the right to bargain, it's a civil liberty we have here in Canada and Quebec. When you have government trying to circumvent that, it's a danger. And it won't be recognized by the Supreme Court. This is why we have done work on the criteria of the essential services in the first place 5 years ago. We're just replaying the same movie from 5 years ago, again, with the complicity of Monsieur Boulay. I don't understand why. He was the minister who redefined the criteria in the first place. What are we doing? It's kind of a circus where he buys time, 5 to 10 years, because it's long to go up to the Supreme Court. And with those years, he want to have this tool to circumvent. He saw that it worked at the federal level for a few years because it's not going to be adopted. It's not going to be permitted by the Supreme Court at the federal level as well. They interpreted very, very largely the federal code, the labor code. It's going to be destroyed at the Supreme Court sometime in a few years, but it takes time. So he's just buying some time.